My name is Amy Kapczynski. I am one of the leaders of the LPE project, and I teach here at Yale Law School. And I'm really, really delighted to have this panel that we have before us about law and political economy and civil procedure. There's an event both today and an event with some parallels and some differences on Thursday in New York City, which if you're really a CivPro stan or an LPE stan, you should just zoom into both or go to the one in New York if you're there. And I'm really delighted about this because it's been a sort of a long time coming in discussions about LPE and CivPro that I've been having with various people on this panel as I'm trying to sort of learn and think about what the interesting work law and political economy analysis might do in the civil procedure area. So we have this terrific panel. I'm going to hand it over with a hearty welcome to all of you. Hand it off to Judith Resnik, who is going to get us started.
Well, hi. We should be in a seminar room, but we're in a capacious room with lots of ambition. So I think the way to start is through Exhibit A, Federal Rules of Civil Procedure, which is in 1938 after it's promulgated. Yale Law School is pretty Yale-centric. There's a way in which there is a real connection to the Yale Law School with the federal rules. J. Willie Moore was working with Charles Clark, and there wasn't a course called civil procedure. There was practice, there was remedies, there were a whole bunch of different things. And then there was this idea, how am I going to sell the political economy of these rules, and how am I going to generate a national infrastructure of lawyers whose identities will be keyed to the thing called the federal courts? So actually there was a book party for Professor Dean Robert Post, and I gave one of the toasts for his 2-volume set of the Taft of the Holmes devise on the Taft justiceship of the 1920s. And so the invention of the federal rules, the U.S. Supreme Court gets its first courthouse of its own in 1935. The Judicial Conference of the United States comes into being under Taft in 1922. And so this whole infrastructure is a made thing with a group of folks with economic resources, developing a bar, interacting with a national economy. And therefore, there became a course called civil procedure in law schools around the country. About half the states adopted versions of this early on, some of them static conformity, some of them dynamic. And then that class started pivoting on, as if the rules had, or maybe they do, forms of their own autonomy. We'll hear more about it. Now, many decades ago, Owen Fisk, Bob Cover, and I thought the construct was inappropriately modified, that calling it civil or criminal or administrative, that there was a thing called procedure. And then in the next edition, it's procedure and its alternatives, because the question of who can call whom to account with some public vector of accounting is a project of why do you give a damn what the process is, and civil versus criminal versus administrative misdescribes the questions. And for many of you, or some of you who know, Goldberg versus Kelly is, of course, another way to try to ask, why do you give a damn about procedure, and how to think about it. And in terms of political economy, if you're asking it in the context of Goldberg versus Kelly, you're opening by asking about people who have very limited resources, looking to legal systems to protect the flow of the very little bit that they've got. So federal rules get to take center stage and are, I think, and we have some empiricism here, but I think lived experience will also tell us that there are many courses that either march through them or put them, and certainly many who put them at the center. Taking the tiny federal court system of taking bankruptcy filings of 440,000 roughly, the 250,000 civil and criminal filings annually, and in that set of activities, a quarter of the people who file in federal court, not counting civil, don't have lawyers. More than a half on appeal don't have lawyers. And the production at the Court of Appeals of the under 40,000 this last year of opinions, 85% of them weren't published. And the story in terms of the economic needs. So that's a little bit of a longer way of saying this is mostly irrelevant, not just to people not in the federal courts, but actually it's not user-friendly for the people who are in it, although it's much more user-friendly than some other systems. If you look stateside, we know that depending on how you count, there are 40 to 80 million cases, and depending on what you look at, they're lawyer-less with great new work done on these issues. They're lawyer-less in about landlord-tenant. Well, there's one side lawyer in credit collection and eviction. There's no lawyers in many family disputes. So 80%, something like this, depending on how you're talking about. That system is so much larger, obviously, ipsa dixit, than the federal system. And that doesn't count administrative agencies, federal or state, social welfare agencies in the United States in the federal system have larger dockets than more than 500,000 cases in the Social Security Administration. And totally missing in action are all the people forced out by the FAA, by the US Supreme Court's interpretation of arbitration. I personally recoil at calling it mandatory or forced, since nobody uses it. And actually some of the materials that people get when they do try to arbitrate make the federal rules of civil procedure look like not bad prose and more accessible than not. All of this is happening in a technological revolution of sorts. I was just zooming into a long conference in London about the degree to which courts are online and what not just e-filing, but e-decision making, or whatever that means, is happening as well. So all of this is a backdrop to the appropriate intervention by LPE and a lot else, asking the question of what is the project of both introducing people who are entering law school to thinking about a structure of adjudication to the extent it exists? What demand should be made on it? What have we inherited? And what should we dislodge? And for those of people in my first step is to ask everybody who takes the first day class to draft an informa pauperis affidavit to start talking about the costs, the fines and the fees, and the financing of a system in which we are all participants. So that is one way to introduce people who have written, and here's my exhibit B, is just some of the writing that they have, and I hope you're posting. We exchange materials, and I don't know what's posted in terms of opportunities to read the book, Critical Guide to Procedure, and the like that's there. And Luke has a long article, and Danya's written at length and thought about this along with Brooke. And and you're all posted as introduced, so I shouldn't reintroduce you, or am I supposed to, you're self-credentialing.
We need no introduction.
Except your name, so that unless people have checked the web very carefully. So we thought it would be helpful to first start. I wanted to push Luke to first tell us, when he says there are more initials in my life than I can bear. When I say LPE, or law and political economy, and then when I say it in the context of something called procedure, what is it that I am saying, and why do I want to put them together? And then there are directed questions for everybody, but we're in conversation, and the idea is that people will speak with plenty of time for interaction.
Great. Well, thank you, Judith, and okay, yeah. Thank you so much, Judith, and thank you, Amy, and thank you to Corinne and Helia for putting this together as well. And it's a big question. I think of LP in part as a project of analysis, critique, and reconstruction that seeks to widen our horizons about what the economy is and what the project of democracy is vis-a-vis the economy, and the role that law plays in all of this. So on the way that one might think about the economy, I think that to speak in LPE is probably to reject neoclassical thinking about the economy that assumes market baselines and forms legal analysis around questions of efficiency, marginal utility, wealth maximization, and the like. It's to functionally understand markets and the economy, forms of power, constraint, and coercion with them, so sort of open the curtain and look inside various economic arrangements and what they look like. And it's to think about how the state and law as its instrument fundamentally creates and structures those conditions. So in some ways, it's a return to sort of institutionalist and functionalist legal thought that we saw in the first Gilded Age, but it's also a renovation and revivification of those ideas, focusing on gendered and racialized forms of inequality and subordination. And when it comes to democracy, it's opening the horizons by understanding that the project of democracy is not merely just tinkering with efficient market relationships, but thinking more richly about the role of the state, politics, and law in structuring the economy. So to begin the conversation of how we might think of procedure in LP terms, and I really mean begin the conversation because the big question is you can't talk about economic power, inequality, and marginalization without talking about procedure. Procedural design and rules deeply bear upon these things, and they're also in our system largely transsubstantive, right? So whether you're talking about consumer protection or civil rights or labor and employment law or various others, procedure matters. And because courts have been centered in enforcing those rules in our neoliberal era, there has been a backlash against procedure and an attempt to constrain procedural rules and courts because they play this regulatory function. So an LP kind of procedure might begin by both centering procedure in the struggle between democracy and the economy and telling its history from that perspective. And then normatively, it might raise complicated questions about how we think about procedure along the way. So LP scholars call for reorientations from efficiency to power in legal analysis, from neutrality to equality and anti-statism to democracy. And civil procedure, especially even just taking the federal context, is far removed from those orientations. So Brooke's work has taught us about the Supreme Court privileging efficiency, which it defines as reducing litigation costs and mostly reducing corporate defendants' litigation costs in its procedural decision-making, and the Roberts Court has certainly minimized questions and considerations of power as it interprets the federal rules of civil procedure or the Federal Arbitration Act and the like. Then there's the move from neutrality to equality. The federal rules are premised on a vision of neutrality, cleaving procedure from substance and thinking of civil rulemaking as occurring beyond a veil of ignorance. And so Danya has written powerfully on the relationship between neutrality and inequality in our federal rule system. None of this is to deny that procedural rules can and have had really equalizing effects in certain ways, right? For some time, the federal rules opened a broad litigation highway, and there's evidence that Judith and others have written about that civil rights and equality goals animated at least the 1906 amendment to Rule 23, which created the modern class action. But if you look at Rule 1 of the Federal Rules of Civil Procedure, which lays out their ethos, you will not find equality, right? You will not find equality values. And then finally, the democracy story is not particularly rosy today. Judith has written about failing faith in courts in procedure as democratic institutions, about the privatization of process. Helen Hirschkoff and I have written about how corporate manipulation of jurisdictional doctrines is part of a larger story of oligarchic drift and democratic erosion. And then the last thing I'll say is one could ask broader, more difficult questions about democracy that maybe we'll all talk about today, which is in light of the modern history of procedure and courts, should we center or decenter courts and procedure in efforts to build a more democratic, egalitarian, and inclusive political economy?
That seems, thank you, and that is a good segue to ask Brooke, who edited a book called Critical Civil Procedure. I have the title right? Close, you can edit it. So how does saying critical intersect or not with LP, if I'm being pushy about what the category and analysis, and I have no idea what democracy means in the conversation yet. So if I want to push, you didn't say LPE, you said critical. Give us the right title and explain more.
Yeah, I think the title's controversial because NYU Press made us change it. So I wanted it to be called Critical Procedure, right? Which you were right. Yeah, you're on the old title. But they didn't like that. So it's a critical guide to civil procedure, a collection of essays. I think that the reason that I think we chose critical perspectives is because my work is very much anchored in race and gender and the intersection with procedure. So that's kind of where my thinking was. And we were calling on critical theory at that point to really think about a way to orient ourselves as scholars and also our students into thinking about civil procedure. So it made sense to use a critical lens, which of course brings a different approach to how you think about the procedure and also deconstructs it. So we use that as an entry point. I do think there's a lot of overlap though, right? Or I guess, as you know, Danya and I have been talking about this afternoon, we've kind of been legal realists all along. I think we've been LPEs all along, maybe is what our answer is. I think to some degree, a lot of proceduralists have already been doing this work. We just didn't really have a way to kind of brand it, to kind of bring it together, to have it connect across other substantive areas. And I think that this is a way to really think about doing it. But the critical guide to civil procedure does just what Luke has been talking about and what Judith has been talking about so far, which is to just take these areas of civil procedure that I think we feed to our students as if it's just some neutral set of principles, and ask our students and ask ourselves as scholars to really think about, wait a minute, how does this really impact the practice of law? How does this really impact individuals? Where did this come from? I always say to my students, it's not like the rules of procedure came down like the 10 Commandments, right? They were created by humans who had a political agenda. They were not neutral actors, and the folks interpreting them similarly are not neutral actors. So it's a way to really think about that. I think the other thing I want to say though is that we're having a backlash. I think backlash is such a good word for everything that we're seeing right now in our broader world, but also in the world of civil procedure. Because I think, you know, if you look back at the work that Judith did in, you know, decades ago, really, there was a lot of this already being said. And really, it was Judith and maybe a few other folks who were really challenging this construction of procedure. But in the last like 10 or 15 years, I think a lot of civil procedure scholars have been taking up this mantle and really thinking about this, inspired a lot by Judith's work and a handful of others. But we're now having a backslide, right? I feel there's this pressure to get back to, oh, just be technocrats, like just really think about what procedure is. Like, do you have standing or don't you? You know, like we're robots. Like it's like AI deciding what we're doing. And I get that sense in the field, both because I think there's a backlash against wanting to talk about race and gender and sexual orientation or anything that others someone. But we're so tired of talking about it. Like, do we have to keep talking about it? And the point is, yeah, you got to keep talking about it because it is where we're at and it is our lived experience. So I think we're experiencing that backlash in procedure as well. So I'm really happy to see this group of folks coming together and really a way to organize us around this. I think the last thing I want to say, though, is that we also need to take back some concepts. And so I think that that's what I really love about this approach is that there's a way in which some of these concepts have been turned on their head. We're seeing that with the way folks are using discrimination. This idea of reverse discrimination actually doesn't exist when there's no power differential. There's no such thing, right? Just as that is the case, this idea that neutrality is owned by one part of the movement or one political process, or this idea that power is owned or that efficiency is owned by one political power or side of the movement is just untenable, and that we need to take those concepts back and really think about how we're defining them and reconstruct them in a way that is nuanced and complicated, but also more accurate to the way that it functions in the world. And I think that's a really important piece of this, because instead of creating our own separate set of vocabulary words, I think we need to take the concepts back and make them our own in the way that is more resonant with what is really happening. And so that's really a lot of what the book did, was trying to just give us a way to think about these concepts more critically. I think had I known more about law and political economy at the time, that would have been an interesting access point as well. But I do think we're all speaking in the same language. I just think that there's just different ways of coming at it. And I think the bigger this tent, the more powerful it'll be.
Danya, you're right with perspective. Do you want to call yourself LPE, or do you want to, how do you describe the lens in which with which you approach many of your interesting articles?
It's such a great question, Judith. I think when I take a look at what I'm going to call sort of the manifesto piece from the Yale Law Journal from 2020, the one that sort of sets out and aims to kind of untether the already existing energy within the academy thinking about law, to think really deliberately about the political economy of law in all of its different iterations. That piece, right, lays out these kind of cornerstones of conceptual categories, right? The way in which the old order, the 20th century synthesis was operating. So a kind of commitment to efficiency, but footnote, that is a very narrow definition of efficiency. Something we covered, Brooke covered in procedure in a piece called The Efficiency Norm several years ago. So 2017, 2016, yeah, 2016 maybe even earlier. Neutrality, something that is so palpable in procedure because it creates a big political problem for people thinking about procedure and its material effects, because the kind of very express commitment to neutrality in procedure makes it very difficult. I guess this is what Luke was alluding to, very difficult to advocate for courts and rules that actually attempt to intervene in the economic distribution of resources in society. And finally, that non-political commitment. Again, procedure, U.S. civil procedure, right? Specifically, this federal rules of civil procedure created through the Rules Enabling Act, again, has not just an express, but a statutory mandate to be non-political, right? To not intervene in, expand or contract a substantive right. So it's created a real struggle in procedural thinking and procedural scholarship. So I guess in some ways I would say those are the categories underlying and the kind of foils against which I am writing and have been writing for far too long now, longer than I care to admit. But and so yes, I think quite naturally procedures in some ways to me feels like a no-brainer law and political economy fields. And as Brooke and Luke suggested, actually there've been beacons of light carrying that flame of law and political economy, or specifically a political economy approach to understanding courts and their rules and how they operate, that kind of was a through line. It never disappeared, right? From the 70s through the 80s, 90s to today, kind of rejuvenated today. But the way that I would tend to think about my work is, and I think this is also in line with you, Judith, is as an examination or a study or thinking hard about courts and how they impact the distribution of rights and resources, and their rules as kind of a part of how they operate and a part of how they are helping to reproduce, create, reproduce, and distribute inequality, I would suggest. And in so doing, I would say, my sense is it is very difficult to understand, or no, sorry, it is very easy to miss the global dimensions to the political economy of courts, because courts seem really localized and procedure is jurisdictionally bounded. It's a field that really lends itself to thinking, kind of limiting our thought to the domestic drawn borders. And that really can make it hard to understand what's going on in procedure, because frankly, the political economic forces that have shifted procedure over the last 40 years are international ones, right? It's an international economic order. And so if I was going to think about the categories that a political economic approach to law must engage in, I would add a fourth one in, which is to collapse that boundary in our structural, in our kind of mental apparatus for thinking about law, so that we're not thinking that domestic and international are so distinct, or global are so distinct from one another. I think they inform each other, and they're kind of engaged in a constant feedback loop.
Mark Galana wrote an article, Why the Haves Come Out Ahead, 1975, which was to understand how repeat players, RPs, play for the rules versus OS, one-shotters, who can't play for the rule structure. And so the idea that there's a political structure with interest to be served. Courts were institutions of creditors and institutions of exclusion for centuries. So one way to flip it is to say, oh my goodness, we think they're ours. So instead of, so just on the, picking up from Danya on the redistributive capacity and practice of courts, there are moments and times and places and decades in which courts are instruments of recognition. I teach in this room about sovereign immunity and tell my students I can't understand how anybody can say it's somehow not dignified to be a litigant, since people didn't have juridical capacity. So what's the indignity of being called to court? It's dignity to get into court, right? As we didn't have juridical personhood, many of us in this room. So I just think that in terms of which lens you're looking at, one lens is these are instruments of authority. These were actually for a while corralled by people who had less authority. And some of the people who had authority wrote rules that made it possible for some people without to make their way in and make us think that it's kind of birthright citizenship to have courts as institutions that ought to be responsive, and then the critique flows that they're not responsive enough. So I think one is to appreciate the political movements that came before us that made this a place, a field in which we can participate. I wanted to push a little bit on the question of technology. As I understand it, as an LPE and beyond question, as I understand it, one company owns 60% of the platforms of all the state court data. And as I understand it, the contracting process is such that if I want to change something so I could text you to come to court, that wasn't in the original contract. And if you say who owns the data, it's owned by the state, but where is the data and how do I get it? And this issue on the global port exists with great other countries very interested in e-transaction and the like. So I wanted to ask you all about how the insights that you have from observing and watching transactions that have come from a tradition of bricks and mortar and are now moving in many directions. What are the paths and directions? That's one question. And then the second, since we're in a law school and it's partially about law teaching, how are the ways to integrate these issues into the practice of something And as the no hide the ball, obviously I've already suggested that a first-year procedure course ought to look very different than the one that many people offer. And that there ought to be the mainstreaming of the conversation rather than as a boutique activity or a 1%, to borrow from a famous article from Brooke. So help, what's the interaction with the new technological, before we get to even AI, we're just in some other parts, which AI will be part of. You want to go in the same order of conversation. And then if you could also ask about the teaching practice or talk about it, and then we'll grab questions right thereafter or comments. You don't have to ask a question.
I think the technological part, the paths and directions question is really interesting because honestly, there was so much promise, I think is what's frustrating, is that there was this way in which I think initially we thought about even simple things like virtual courts would be so access granting. And in the context that we live in, that's just not the way that it has worked out. So it's almost like when we teach personal jurisdiction and I say to students, it's easier for them to make a transition from thinking about some physical product making its way and virtually making its way because your minds, you see the matrix like you've never had that problem. So you can make that transition where some of the, octogenarians on the court have a difficulty with that because it's just not their lived experience. I think similarly, a lot of us, as we approached how technology would impact litigation, we thought probably Pollyannishly that it would be this way to open up access and do things. And it's too bad that I think folks are talking about this, but that there is this way in which it has been used against that kind of access granting agenda item. And I think that's frustrating. And so I think that that's what I had hoped. I think when I first started thinking about technology was this way in which it would open up the courts. I don't think that has happened. I think there's still that potential, but I don't know if you two have anything to add on that one.
Should I jump in?
So I think one has to assume that the same dynamics, the same kind of structures of inequality and the kind of political scramble for resources, right, to dominate those by the haves, to use Mark's great term, will reproduce itself and maybe intensify itself unless we are thinking deliberately and really in an organized fashion attempting to push back. And so I worry a little bit, particularly with the language learning models and this idea that now we can just have lawyers for everyone, but there'll be AI lawyers for everyone, that there's a sort of always the unwillingness to deploy real resources to democratize and to equalize, and the kind of fantasy that we can have a quick fix, a cheap quick fix. So AI will be this cheap quick fix. And that I find concerning, not because there isn't some potential to use these tools to save time for efficiency purposes and in ways that actually can increase the engagement with the substance of the law. But because if we're thinking of it as a quick fix, and I'm not suggesting anyone in here is, but I can say I hear that a lot from policymakers and deans of law schools and whoever else, that this can be this quick A to J fix, access to justice fix. That gives me like a kind of visceral pain in my stomach, like gut reaction. So I worry, and I think we are behind the ball actually in theorizing about it. And I'm thinking about the 60% of the state court systems having the same platform. To be very old school lefty, I would say, great, and let's get the other 40% into the same system, and then we can take control of that system, right? Like, because it's more efficient and useful to the public, but it has to be democratized.
Yeah, I agree with all that. It all has to be thinking about sort of how procedure connects to broader currents and the need for building countervailing power and how that might translate to procedural design, right? Because when I think about sort of the concern that powerful large corporate forces will use these technologies to sort of bend the court system to their own ends. I was thinking about the Pound Conference in 1970, dissatisfaction with justice, and you have the rise of the litigation regulatory state, right, where procedure and courts are really becoming more used. They've always been used, but more used in the enforcement of regulatory statutes. And on the right, there's a narrative: courts are in crisis. Let's simplify things. Let's move things up. But then on the left, there are also a lot of folks who are skeptical of courts and think about the promise of ADR. And you don't sort of have a left or center left procedural movement to think about re-envisioning procedural rules for their role in the regulatory state. And so I kind of think of technology along similar ways. Two other things quickly, sort of like, what are the paths and what's happening? So much of what's happening in state court is debt collection, as Daniel Townsend's work shows us, by a few companies who are the largest civil plaintiffs in the United States, and the party against whom they're litigating is typically not lawyered, right? So I think of debt collection and housing as particularly sort of like what's happening. And then that makes me think about how Judith's last question, which is how we teach, right? Most civil procedure classes spend nearly half of the semester on personal jurisdiction. And I don't want to burst anyone's bubble, but if you become a civil litigator, you may never litigate a personal jurisdiction issue. For most civil litigators, personal jurisdiction is a sentence in the complaint, right? Which is not to say that there aren't interesting personal jurisdiction cases, but also some of the things that we also teach in civil procedure don't work the way in state courts that we teach when we talk about default judgments, right? Pam Bookman's work right now shows us that some of the black letter law we teach our students about how default judgments works actually don't work in many contexts in courts. So there's this broader question of sort of the way we teach very much fits with the book that Judith held up of the Federal Rules of Civil Procedure, and taking people through a civil litigation process, which is not one that many folks encounter. And it raises the question of how do we rethink the first year civil procedure course, but with the difficulty of having to prepare students for the bar exam as well, where personal jurisdiction will matter, right? And Erie will matter and the like. So there's, I think, a difficulty and tension there as well.
Want to protect time for comments and questions, interacting. Everybody has a lot more to say. Brooke was about to say something, but I just cut her off a little bit to invite, I do cold calls, although I try to advance notice a little bit. But the question, you're interested, so help us understand how to be in conversation with you, please. And just say your first and last name.
My name is Fredric. I'm at Yale Law School. So my question is alternative dispute resolution something that algorithms is like antagonistic to, or is there a way that like RESTful procedures could have like a positive value for algorithm scholars?
Why don't we collect a few comments and questions at the same time? Because that's an excellent prompt, and we'll take notes. Go ahead, Gustav.
So two questions, one general. So a recurring theme from your introductory remarks is that LPE is a very close follower onto critical legal studies. So I'm curious if you guys could articulate anything new that you think LPE adds. Professor Coleman mentioned that had she been aware of LPE, she might have added something different to her critical work that she wrote. So I'm curious to hear that. And the second thing, following the discussion of ADR, I have written a little bit on arbitration, and curious, there's a big theme in LPE about attacking the sort of like aristocratic powers of the courts. So maybe there is a value to sort of less formal dispute resolution systems, or something that would not cede more control in policy making. And then following on from that, like But on the other hand, we certainly don't want more. So how do you guys think about that?
And go ahead.
Hi, thank you all for being here. My name is Tanvir Singh. I'm also a 3L. Just Professor Coleman, you mentioned standing, and it reminded me, Professor Gluck assigned your Vanishing Plaintiffs article in our 1L year, so it's been a little while. But much of the repeat player dynamics are also how repeat players are able to shape the scaffolding of the federal rules of civil procedure in a way that plaintiffs are not, right? So if you're a repeat player, maybe you have big law firms or litigating prowess to say, 12v6 should be interpreted a specific way, in a way that a plaintiff that is engaging with on a one-shot basis with FRCP doesn't see that blurring potential. And is there a move around the way courts are potentially reading the FRCP as a scaffolding that is malleable for defendants, but not so for plaintiffs?
And Amy, did you want to add a comment or question?
Well, I'll just add one thought, and I appreciate you raising the technology question as somebody who teaches about intellectual property law. And I think one area where the construction of the economy and its rules really will shape, the way that procedure happens is precisely in this area, right? Whereas you're pointing to, Judith, there are a background set of rules about ownership, which in some sense you might say that the federal, like the states own, the data in the sense that they have access to, but they don't really, if the database, which belongs to this private company, is held by them. And so I, to the question about how to think about sort of technological power, I mean, there is one thing that I find useful about the political economy conversation is sort of drawing together outside of our silos, right, of civil procedure and intellectual property law. I mean, what's happening at the intersection of these two? How did we end up in a world where data is not only owned by nobody, but all of it's actually owned by tech companies? How did that happen? And then what are the rules or issues that we'll face trying to unwind that? And so to the question, can we get everything into 100% system and then take it over? Well, let's talk about Monsanto and the constitutionalization of trade secrecy and the rules. And Judith and I worked together on some of these questions about the way that corporate secrets are also protected in court. And so I do think that there's that sub-theme about what has happened around secrecy and corporate secrecy is probably it's a generative one to think about with both respect to technology and also access to courts and court proceedings. So that's more of a comment than a question, but maybe.
To just tie that, oh, go ahead, please.
Well, my question is, thinking about tech companies owning all the data, I feel that, we all know that the conservative kind of backlash in mentioning against procedure is not only an academic movement, but is also extremely well implemented, right? And they have these organizations that go about at state, federal, every level and implement their will. Do you think we're missing that in the LP movement? What are the instruments that you're using or that you would like to see to transfer your academic work into action?
So just to tie the comments about alternative dispute resolution to Amy's comments about publicity, power, transparency, access. And the formal, informal is one axis. Is it friendlier and what does friendly mean? But the other part is who has authority and can you see it? And is there an obligation to perform it in public or is it a deep form of privatization? So the issue around, one version is if ADR is the best thing since sliced bread, let all of us volunteer to go eat sliced bread. It's not so voluntary anymore, but the other is administrative agencies were ADR in the 40s. So I think there's a sort of, in a world of non-binaries, inside courts, there's a lot of interaction, managerial settlement and the like, and a lot of negotiation and a lot of compromise, sometimes in published decisions and sometimes without publication. So to model one as one and one as the other is to miss the overlap. But the other in all of these on the political power question is who gets power under these systems. And of course, there's a big left critique of less formality as not a system that empowers, coming to your point. Let's go back down the row and see about more suggestions.
I'll jump in on the ADR, the set of ADR questions. So Richard Abel edited a volume, a two-volume book called Politics of Informal Justice in 1982, which I think paints a very damning, I say 1982 because that Pound Conference is 1976, I believe. So it is very early in the birth of this informalism movement. And it paints a very dark, bleak picture of informal justice, at the politics of the informal justice. And it has a kind of focus on, it's interdisciplinary, so it does really take a lot of the essays in the piece, take a kind of a political economy approach and thinking about like, well, what are the structures of informal justice and who is helped and who is hindered by these, right? Who is empowered and who is not. And a number of the essays tie in informalism with the deregulatory movement. So just as you pull away resources from neighborhoods, you say, why don't you have a neighborhood justice center where you mediate with each other, right? So we're not giving you anymore the typical housing, disability, social security, schools, like fully funded schools, et cetera. But now we think you have problems and you don't seem to be getting along and you're getting picked up on low-level criminal charges and like have a conversation in court, or come to court, have a conversation, and then the non-judge will twist your arm and make you do it. So that could use updating, right? 1982 is a really long time ago. Most of us were not yet born in this room. So that could use updating and probably with an open mind. But I suspect the politics of the various forms of managerialism and informal justice are not going to do particularly well on that account. So yes, I think probably LPE ought to be hostile to informalism, not because there's anything wrong with informal management of one's challenges, but because as a state apparatus, it tends to be anti-democracy and a kind of move to strip resources out of a system that otherwise had sort of started to give people, right, that dignity of a stake in the court structure and the system.
I might maybe take this as an opportunity to ask Judith a question or to prompt, because when I think about the themes that are coming up in your questions, one is it better to sort of to just sort of go with informal processes, and the other is what happens when repeat players shape the scaffolding. Part of what I think about is how deeply embedded courts are in the U.S. system in a relatively unique way in effectuating economic, and to the extent we have them, social rights. And if that's the case, right, whereas other countries focus more on the administrative state, don't use courts as much, there's a question of, when Congress and state legislators create all these private rights of action and center courts and procedures, why haven't they funded them, right? And so if we really care about using civil litigation to fulfill these ends, are Congress and state legislators sort of gaslighting us when they create these courts, but then don't adequately fund them and don't adequately provide equalizing measures for folks to actually use them, which is some of the stuff that Judith has written about and is writing about now, sort of the trajectory of courts and why, and sort of the problem of both that we've put so much pressure on courts as vindicators of economic rights, and yet we've chronically overfunded them. And Judith's also written about how when the Chief Justice asks for funding, right, it's often not to expand courts, even though there's more to do. So I don't know if you want to talk about that at all, but
Just a sentence before we turn to Brooke. So first off, and invoking Danya, Around the world, there's a lot of collective action and collective redress. We are US centric as usual, but Deborah Hensler in Stanford has a major database looking at collective action. And actually, I mean, there's somebody here who wants to talk more, teach more next year, in touch with both of us about this idea of thinking through collective action outside the United States as well as inside it. So we have a particular version of judicial review. On the other hand, anybody who's doing environment is going to waive the degrees to which court, green courts, and there are a lot of examples of innovative adjudication outside the United States with totally different standing rules, including France, that invite people in and do something. It isn't the US class action with a big bounty to lawyers necessarily, but there's more of it there. And the, challenge for what you can teach, there's some people here who are helping me as I'm desperately, as usual, on everything that, so the reason to use the federal rules is I can give you one book and I can write 15 pages right now about the financing system of the federal courts. I am actually trying right now, as in tonight, to write a few pages about the funding of state courts, the numbers of judges, and I decided I have to call it crowdsourcing because I can't go, even the thing called the National Center for State Courts hardly tells me anything. And so this issue about, and the underfunded mandated state courts are radically underfunded by the federal government and asked to apply a lot of law. So if we're looking, but it's not a phenomenon unique to courts. So if we're trying to intersect ourselves and say, why are courts special? They have a form of potential which relates to power, which is why you get nervous about too much about lack of access to information about who's doing what with what authority, which isn't solved by 85% not published decisions, by the way, or federal databasing. But so that's the challenge is, how can we provide government services that are disciplined, and how can we do forms of conflict engagement, not resolution, maybe we want to talk about engagement that doesn't pat it down, shove it off, or screw people. And that's the sort of challenge of a system. And when you go to law schools, obviously what I'm suggesting is a revolt around a pushback against the idea that a course, whatever the bar is saying, that an introduction, that an entry to the world of law should not problematize, explain why I have one template because it's got all the questions in it and it's got one workout, but not that it is in any way the center. And I think there are ways, it asks people to read a lot and makes you do your own stuff, that you can do that, which isn't marching through the doctrine, although Danya, the turn, actually, Brooke's turn, law, original understanding, tradition, how are we going to think about, the new constitutional wave is surely is pushing in procedure as it is pushing everywhere else to ask what they thought in 1789. And so that is to be mindful of as well. Brooke, and then I think we have about 5 minutes.
Yeah, I'll just try to hit a bunch of the questions all at once. But I think one of the things is you just abolish the bar, right? And then you don't have to worry about teaching to a bar. So that's Washington's on its way, thank God. The bar exam, not the whole bar. I mean, I want y'all to have jobs. But the idea of the bar exam, that's one way to really change what we're learning and what we're really teaching our students to do. So
Clap for that.
right, yeah, let's do it. Yeah, I know. It's just think about it. It's a great idea. So I think on the vanishing plaintiff piece, it's interesting. The way I've always tried to think about it, and I haven't written this article yet, is that, I think I've danced around it, but there should be like a default retort in the rules or how they're interpreted that is resource disparity sensitive, right? I know that's a long way of saying that. Maybe that's why I haven't written it, because it's really hard to put into place. But I think about it, for example, in the context of summary judgment, like if it's a close call, then the default should be that you deny summary judgment, right? Like there's ways in which the rules could do that work if the rule makers were brave enough or courageous enough to put that into place. I think that's something you could do. It could be substantive, but I think it's true that could happen. But I don't think our rule makers will do that. With respect to the question about, thinking about critical perspectives and how law and political economy intersect on that, I think what I find attractive about the law and political economy piece is that, and this goes to your question too, is that we don't have like a Federalist Society kind of machine around a lot of the way that I think a lot of us are thinking about these issues. And there's a way in which it creates enough space.
Amy's making that.
That's what I think is happening, right? And I think that that's what's really important, is to create a way for us to combat that kind of movement. And law and political economy allows a lot of different places to sit, where I think some people, at least when I was writing the critical procedure book, a lot of folks that I approached about writing the articles were like, but I'm not a critical perspectives person. I'm like, yeah, you are. You're close enough. Like, you don't have to be Derek Bell to be able to have this particular approach and to write this way. And you can gesture towards it. But the fact that you're critiquing this power structure is half the work. So just keep going. So I think that there's a way in which a lot more folks can operate in this way. And I think that you're exactly right. Your instincts are right. Then it needs to be operationalized. You do need more boots on the ground. I think that the challenge, though, is that those structures, FedSoc and those structures, have been working to rights strip or to maintain power. What we're trying to do is expand power and rights grant, and that's always harder. Right, that's always a harder road. And so I think that we have to be honest with ourselves about, mimicking that structure. But I think it's the right thing to do, because I love the American Constitutional Society. They've been great, but they haven't been able to combat the FedSoc movement the way that I hope that this has the potential to.
Can I jump into? There we are. So I just wanted to, on both the question on critical studies, I think I just want to clarify some terminology, and therefore, like, I guess, archaeology of legal theory, because I think it's helpful. So when Brooke talked about critical perspectives and that the draw was critical theory, that's like what's otherwise referred to as your kind of continental critical theory Frankfurt School, that kind of gets pulled up and kind of renovated, I guess, in modern terms, by feminist legal studies, critical race theory. CLS is maybe had some overlaps, but is its own strand. And so when I think about LP, I think I think LPE folks have said this, that the kind of progeny is realists. We're talking now like a century ago, 1920s and 30s. And it seems to me, based on citations and works that are being drawn on, much less the critical legal studies movement of the 70s and 80s. And that really is different from critical theory. Why does any of that matter? I think because LPE is trying to put the economy at the center in a way that really stops being the case in the 70s onwards. And that's even true for critical theory is trying to ditch the economy, right? That's kind of what its kind of political trajectory is to do. So that's probably why LPE would have maybe been a better title for right? Like, it would have been a better capture for the book if we had been in conversation already.
I think that's right. I think the book is a stretch. The title is a stretch for some of the articles that exist in the book.
But partly because it's taking a really big tent approach in a way that's lovely and generative of a lot of ideas. And then I just wanted to say on this question of sort of how do you make it happen? There's this whole infrastructure. And I think LPE has this other great log to place on this fire, which is Luke alluded to. You kind of need a base of power to make demands about how the courts should be resourced and what should be happening in them, and how the rules might expressly put their thumb on the scale to counter unequal relationships coming in. And that would be through attention to kind of movements and movement building. So without a public that one can learn from and draw on, I think it's really hard to make any of this change. We can come up with really good ideas and think hard and develop our own understanding, but we won't see that followed through in the courts.
You helpfully raised Rick Abel's name, because another way to think about the heritage or lineage or genealogy is there's a thing called Law and Society. And Law and Society, Rick Abel, famously a part of Susan Silby, a whole bunch of people looking to try to understand Malcolm Feely here, what did it look like from the police station for people coming into the police station, rather than thinking about it only as what does it look like in terms of the text of decisions. And so this sort of on the grounds kind of set of concerns, which was quite involved with class. I think we undername the role of class in courts and class and lots of other things. That is part of why the economy kind of argument comes to the fore. And so the question I've just been puzzling about a lot is why is the lack of a rallying cry. And access to justice doesn't seem to have a resonance when you're talking, Luke, about underfunding. The State Justice Institute gets like 10 million a year. The US Supreme Court gets 100 million plus a year. But the whole idea that there's been a big movement about access for justice, access to justice, ADR is part of it. There's a lot of it. And so the question, what are the words that would help translate that we're talking about people's material needs and their vulnerabilities? And is it a big 10 or an hour 10? I think those are all, whether these are focus groups and PR people, or what's the vocabulary that will make accessible a set of concerns and claims and empowerment. And so the question about, empower or power or depower, whatever you want, whatever direction, should be at the center of the discussions to clarify the stakes. And I don't know quite if there's a vocabulary that matches those concerns. I think we're at a clock. Even we have a dysfunctional clock in a very rich building. That one's functional. This one that I'm looking at says that it's 11:15, and yesterday it had never been set forward, so we had an extremely long class. So, I think we need to say thank you for traveling and your energy and all that you've written. And I don't know whether you can list all the people's publications, so there are links to everything. Bingo, power. Thank you.
So much. And this history.